Paging Aitken Robertson to courtroom number 2. The jury is back with a verdict. Members of the jury, how do you find the accused? Guilty or not guilty?
Not guilty on all accounts, Your Honor.
Welcome to Legally Speaking. I'm Melanie van Orde, your host. And today I'm joined by Rawi Ashgard to explain what the law really means when it says you must provide a roadside breath sample forthwith or immediately. So Rawi, let's begin by setting the stage for the viewers. What does the law actually mean by the forthwith or immediacy requirement when it comes to roadside police demands?
It's sort of a complex question of fact and law, but basically the forthwith or immediacy requirement includes two components. There's the implicit obligation of the police to immediately demand a roadside breath sample, or such as a physical coordination test. Once police form reasonable grounds to suspect that a person has alcohol or drugs in their body, immediately and without delay. And the explicit component of the immediacy requirement, that refers to the obligation of the detainee to immediately comply with the police's demand. This ensures that the evidence gathered is still reliable and that the person's rights are respected in the moment. According to our criminal code, section 320, if a peace officer has reasonable grounds to suspect that a person has alcohol or a drug in the person's body and has operated a conveyance, like a vehicle, within the last 3 hours, the officer may demand that the person participate in testing. The type of testing is set out in section 320 of the code and includes samples of breath and bodily substances, as well as physical coordination tests. Furthermore, pursuant to the same section, it provides that if the peace officer is in possession of an approved screening device or an ASD, this kind of device, by the way, it screens for the presence of alcohol only, that if the officer is in possession of this kind of device, then the officer may demand that a person who is operating a motor vehicle immediately provide a breath sample to enable analysis of the breath. The officer is not required to have a subjective belief that the person has any drug or alcohol in the person's body or that the person's impaired in any way. Jumping back to the requirement, the immediacy requirement, it implies both as I said, a prompt demand by the police officer and an immediate response by the driver. There's a good case law on this, very recent case law from the Supreme Court of Canada, particularly Regina versus Briault, 2023. And so some of the things the Supreme Court notes in this case is that the existence of unusual circumstances may justify a flexible interpretation of the immediacy requirement. However, the burden of establishing the existence of unusual circumstances rests on the Crown, the prosecutor. However, as per Briault, Supreme Court of Canada case that I just referred to, the absence of an ASD device at the time the demand is made by police is not in itself an unusual circumstance. The Crown, what that basically means is the Crown cannot use that as grounds to argue an unusual circumstance that would perhaps forgive the police's obligation or mitigate the police's obligation to immediately make a demand. Furthermore, with respect to the same case, the Supreme Court notes that a demand made cannot be presumed to be valid in the absence of an ASD at the scene. And there was a further subsequent case law from the Superior Court of Justice, RV Regina versus Barco, 2024. In this case, the officer did not have an ASD device on hand when he made a demand at the scene of the stop after forming reasonable suspicion that the driver was, impaired while driving. From the time the officer made the demand, it took about 5 minutes for his sergeant to arrive at the scene with the device. So it was not on scene, as I said. The accused complied with the demand and registered a fail. Court ultimately found that the ASD demand was invalid. So just to recap, Canadian criminal law requires that demands for ASD or physical coordination tests, those kind of demands made by officers, they have to be made forthwith, which typically means immediately after the officer forms reasonable suspicion. However, courts have allowed some flexibility in unusual circumstances and circumstances where the officer is taking time to prepare the ASD device, assuming it's on at the scene of the stop, or ensuring general safety of the public or the officer's safety. These kind of circumstances may amount to unusual circumstances, which may allow some flexibility with regards to the immediacy requirement. And also, though this is, I guess, a area of contention, there is authority to support that license and record checks can be considered part of the officer's duties at the screening phase if they are directly related to the use of the ASD or the reliability of the results. So what that basically means is that if the officer takes a couple minutes to do a license and a background check to identify the accused and to ascertain safety matters, then they can do that before administering the device. However, they should have the device at the scene of the stop.
Rawi, you mentioned reasonable grounds to suspect. What exactly qualifies as reasonable grounds in these types of roadside stops?
Yeah, so that's a really good question. Reasonable grounds to suspect means that the officer has an objective basis supported by facts to suspect the person has alcohol or drugs in their body. This is a lower threshold than reasonable grounds to believe. And so examples of reasonable suspicion could be the smell of alcohol, slurred speech, admission of consumption, or erratic driving.
So, Rawi, you did touch on this, but can you maybe elaborate on the types of roadside tests that police are allowed to conduct under this requirement and maybe how they will be used?
Yeah, so two main roadside tests the police use to screen impairment at the roadside is the ASD, it stands for Approved Screening Devices, and the other one is a standardized field sobriety test. This includes tasks like walking a straight line or following a pen with their eyes. They're investigative tools used at the roadside to help police decide if further testing or arrest is justified. In the particular case of an ASD, usually after the test is done, you will have three different results. You could have three different results. Either it's a pass, meaning that the roadside screening device did not detect any alcohol in your body. And the other one is a warning. So if you are perhaps starting to reach near the legal limit, then it might register a warning. And lastly, the third outcome could be a fail. And so if it does register a fail, the officers do have reasonable grounds to believe an offense has been committed, and so they can therefore arrest you. And so it's important to mention that the evidence that's obtained at the roadside, which could be the fail result, that's not usually used or adduced at trial. That's not the evidence they use at trial. The evidence that's used at trial is the further testing, more comprehensive testing that's done at the police station. So once you register fail, the police take you to the police station and they conduct generally two more samples. They obtain two more samples, and that's called an intoxilizer. And so that's a way more sophisticated device. And the results obtained from the breath samples of that device, they will be used as evidence at trial.
Well, thank you so much for everything, for all the information today, Rawi. And thank you to everyone else for joining us on the Legally Speaking YouTube channel. So stay informed, stay protected, and don't forget to subscribe for more legal content. Till next time. Thank you for tuning in to Legally Speaking, proudly brought to you by Aitken Robertson Criminal Defence. We represent clients facing criminal charges all over Ontario, providing you with legal support and dedicated advocacy. If you enjoyed this episode and want to see more content, please like and subscribe to our channel. For more information, visit our website. We also offer free books on various types of criminal charges, which you can request on our website or by using the QR codes on your screen now. For legal assistance, call us today or visit our website to request a meeting with one of our experienced lawyers or licensed paralegals. Thank you for watching, and we'll see you next time on Legally Speaking.